They confessed. The DNA said otherwise. A dead-ends investigation. On the night of April 19, 1989, a 28-year-old woman went for a run through Central Park in New York City. She was found nearly 14 hours later, unconscious, in a ravine near the 102nd Street transverse. She had lost more than 3/4 of her body's blood. Her skull was fractured in multiple places. Doctors did not expect her to survive the night. She did survive, but she remembered almost nothing of the attack itself. Within 72 hours, 5 teenagers, 4 Black, 1 Latino, ages 14 to 16, had confessed on videotape to participating in her assault. None of their DNA matched what was recovered from the crime scene. All 5 were convicted anyway. They would serve a combined total of more than 30 years in prison for a crime that, 13 years later, a man already serving a life sentence for other violent crimes would confess to alone. A confession that DNA evidence would confirm beyond dispute. This is not a story about whether these 5 boys were guilty. This is a story about how 5 teenagers, questioned for hours, without their parents present in any meaningful way, without an understanding of what they were actually agreeing to, ended up confessing to a crime none of them committed. And how an entire city, a police department, a prosecutor's office, and a media industry helped turn that false confession into a conviction that took 13 years and one hidden truth to undo. It is worth stating plainly at the outset what this episode is and is not attempting to do. This is not an argument that confessions are never reliable, or that police interrogation as a practice is inherently corrupt. It is a documented account of a specific case in which a specific set of interrogation practices, applied to specific teenagers under specific institutional pressures, produced a specific and provably false outcome, one that the legal system itself, given enough time and the right piece of evidence, eventually acknowledged and corrected. The value of examining it closely is not to indict every confession ever obtained by American police, but to understand, in granular detail, exactly how this particular kind of failure occurs, so that the warning signs present in this case can be recognized before they produce the same outcome again. The world before New York City, in the spring of 1989, was a city gripped by fear of its own crime statistics. The murder rate was near its historic peak. Crack cocaine had torn through entire neighborhoods over the preceding several years. Tabloid newspapers ran near-daily front pages built around violent crime, often using language, wilding, wolfpack, super predator, that would later be criticized as having racialized entire categories of alleged offenders before any court had reached a verdict. The city's political and media environment in this period cannot be separated from what happened to these 5 specific teenagers. Crime coverage in 1989. New York operated within a media ecosystem defined by fierce tabloid competition between multiple daily newspapers, each seeking the most dramatic possible framing of any violent crime story, particularly one involving a young professional woman attacked in a park millions of New Yorkers used regularly. That competitive pressure, several media historians have since argued, contributed directly to coverage that presumed guilt, used dehumanizing language to describe the accused as a group rather than as individuals, and created a public climate in which anything short of harsh, swift punishment would have been politically difficult for any elected prosecutor or police official to defend. Central Park itself occupied a strange place in the city's imagination. By day, it was Manhattan's green heart, joggers, families, tourists. By night, particularly its northern reaches, it had a reputation, not entirely undeserved, for danger. On the evening of April 19th, a group of roughly 30 teenagers from East Harlem entered the park. Some, by their own later accounts and by witness testimony, engaged in acts of harassment and assault against other park users that night. A jogger was struck with a pipe. A homeless man was attacked. Cyclists were reportedly harassed. Several teenagers, including some of the 5 who would later be wrongfully convicted, were near or involved in some of this activity, according to witness accounts gathered that night. This part of the record has never been seriously disputed, and it matters for understanding why police so quickly connected this group of teenagers to a far more serious crime that occurred nearby around the same time. It is worth being precise about what this means and does not mean for the 5 men at the center of this story. The acts of harassment that occurred in the park that night, involving a larger group of roughly 30 teenagers, are a documented separate matter from the assault on the jogger. Several of the 5 were later found, including by their own admissions and by contemporaneous witness accounts, to have been involved in some of this separate harassment, which resulted in several of them facing charges related specifically to those incidents, distinct from the rape and assault charges connected to the jogger. That distinction between documented involvement in one set of incidents that night and the entirely separate DNA-disproven allegation of involvement in the assault on the jogger became, for years, one of the most persistently misunderstood aspects of the case in public discussion, with many people conflating the two into a single, undifferentiated narrative of guilt that the physical evidence never actually supported for the more serious crime. But a separate, far more serious crime happened elsewhere in the park that same night. The near-fatal assault and rape of a young investment banker who had gone out for her regular evening run. Police, arriving to a chaotic scene of multiple reported incidents across the park within a short window of time, began rounding up teenagers who had been in the park's northern sections that evening, many of whom had no connection to the assault on the jogger and had never encountered her at all. Antron McCrae was 15. Kevin Richardson was 14. Yusuf Salam was 15. Raymond Santana was 14. Corey Wise was 16, old enough, under New York law at the time, to be interrogated without an obligation for police to specifically contact a parent before questioning began, a detail that would matter enormously for what happened to him specifically over the following days. Each of the 5 came from working and middle-class families in Harlem, several of them with no prior contact with the criminal justice system at all. Yusuf Salam's mother has described, in later interviews, being present at the police precinct for portions of her son's questioning and still being unable to stop what was happening in the room. A detail that illustrates how little practical protection the legal standard of the time actually provided, even when a parent made every effort to be physically present. Kevin Richardson, the youngest of the 5 at 14, had been on his way to a family gathering that evening before being swept up with the larger group. None of the 5 knew each other especially well before that night. None had any documented history connecting them to the specific area of the park where the jogger was attacked. What connected them, in the eyes of investigators working under enormous public and media pressure within hours of the assault, was simply that they were teenagers of color who had been present somewhere in Central Park that night, at a moment when the entire city was demanding an answer for what had happened to a young woman now fighting for her life in a hospital bed. The crime. The victim, whose name was withheld from public reporting for years under standard practice for sexual assault survivors and who would not come forward publicly until 2003, entered Central Park at approximately 9 p.m. on April 19th for her regular evening run along the park's roadways. She was attacked somewhere near the 102nd Street transverse, dragged roughly 300 feet into a ravine, beaten with a blunt object and sexually assaulted. She was found by two men walking through the park at approximately 1:30 a.m., more than 4 hours after the assault is believed to have occurred, unconscious and suffering from severe hypothermia, in addition to her other injuries. She was rushed to Metropolitan Hospital in critical condition. Doctors documented a skull fracture severe enough that one eye had been displaced from its socket. She had lost so much blood that survival itself was, for the first 24 hours, considered uncertain. She remained in a coma for 12 days. The medical details of her recovery, documented later in her own published account, illustrate the severity of what she survived. Multiple facial fractures, extensive blood loss requiring transfusion of roughly 3/4 of her total blood volume, brain swelling severe enough to require emergency intervention, and a recovery process that included relearning basic physical and cognitive functions most adults take entirely for granted. That she survived at all was, by the assessment of her own treating physicians at the time, closer to unlikely than expected. When she eventually woke, she had no memory of the attack itself, a common and medically documented consequence of the kind of traumatic brain injury she had sustained. She would never be able to identify her attacker or attackers from memory, because she genuinely had no memory of the event to draw from. That absence of victim testimony would become, in hindsight, one of the most consequential facts of the entire case. With no memory from the survivor herself, and with physical evidence at the scene that was limited, and crucially, would not be fully analyzed with modern techniques until years later, the case against anyone accused would rest almost entirely on two things: circumstantial connection to the park that night, and confessions. Detectives from the New York Police Department, working the case under intense pressure from a mayor's office, a police commissioner, and a media environment already saturated with coverage of the assault, began questioning the teenagers who had been rounded up from the park's northern end within hours of the attack becoming public. The pressure on investigators to produce results quickly was not incidental to the case. It was, by most later accounts, one of its defining conditions. Mayor Ed Koch publicly described the attack within days as one of the worst crimes he could recall in his tenure. Police Commissioner Benjamin Ward faced immediate public and media demands for arrests. In an environment where a city's political leadership, its police department's public standing, and an intensely competitive tabloid press were all, simultaneously, demanding rapid answers to a horrific crime against a sympathetic victim, the institutional incentive to produce a resolved case quickly, rather than a slow, methodical one, was, in hindsight, enormous, and largely unchecked by any of the safeguards that might otherwise have slowed the process down. None of the five was formally arrested with physical evidence connecting them to the specific crime scene. What followed instead, over the next 2 to 3 days, was a series of interrogations that would later be recognized by courts, by legal scholars, by the police department's own later reviewing officials, as a case study in how false confessions are produced. It's worth being precise about the timeline, because the speed of it is itself part of the story. The assault occurred the night of April 19th. By the afternoon of April 20th, less than 24 hours later, police had already begun questioning multiple teenagers who had been in the park. By April 21st and 22nd, several of the five had given statements implicating themselves and each other. Within roughly 72 hours of a nearly fatal assault on an unidentified victim who could offer no testimony of her own, the New York Police Department had produced not one but 5 confessions, an outcome that, viewed from any distance at all, should have raised at least as many questions as it appeared to answer. The initial investigation, the interrogations of the 5 teenagers, took place over roughly 24 to 30 hours each, spread across multiple sessions, without food, sleep, or, for significant portions of the questioning, the presence of a parent or attorney in the room. Under New York law at the time, minors could legally be questioned without a parent present as long as reasonable efforts were made to notify a parent, a legal standard that left enormous room for interpretation, and that, in practice, meant several of the boys spent hours being questioned before any parent was allowed into the room. And in some cases, parents present were kept from meaningfully intervening once the interrogation was underway. Detectives employed the Reed technique, the standard interrogation method used by American police departments at the time and for decades afterward, a method built around presenting a suspect with claims of overwhelming evidence, whether or not that evidence actually existed, and offering a path toward relief from the interrogation itself in exchange for agreement with a version of events the detectives had already decided was true. Each of the 5 teenagers, over the course of these interrogations, eventually provided a statement, several on videotape, describing participation in the attack on the jogger. Critically, these statements did not agree with each other. The boys' accounts of where the attack occurred, what weapon was used, who held the victim down, and in what order events unfolded, contradicted one another in significant, documented ways. Several of the confessions also contradicted basic physical facts about the crime scene that would only become clear later, once investigators had fully processed the location. Legal analysts who later reviewed the videotaped statements in detail noted a pattern common to coerced false confessions. Several of the boys appeared to be repeating details that had, in some form, been suggested to them during hours of prior unrecorded questioning, rather than volunteering information independently. The recorded portions of the interrogations, typically the final segment of a process that had already run many hours, captured only the end result of a process that had, by that point, already shaped what each teenager was prepared to say on camera. Defense attorneys would later argue this distinction was crucial. A jury watching a taped confession sees only the polished final product, not the many preceding hours of pressure, exhaustion, and suggestion that produced it. None of this internal contradiction slowed the case down. Confessions, especially videotaped ones, carry enormous weight with juries, a fact interrogators are trained to understand, and a fact that made the recorded, on-camera nature of these statements particularly consequential. Jurors watching a 14-year-old describe on tape his own involvement in a brutal attack rarely stop to ask what happened in the 18 or 20 hours before the camera started rolling. Semen recovered from the crime scene and from the victim's body was tested against all 5 defendants before trial. None of it matched any of them. Prosecutors moved forward with the case regardless, arguing that an unidentified 6th attacker's DNA simply hadn't been recovered from every relevant sample, and that the confessions themselves, combined with circumstantial evidence placing the boys in the park that night, were sufficient for conviction. This particular argument, that a DNA mismatch could be explained by the presence of an unidentified additional attacker, rather than treated as evidence undermining the confessions themselves, deserves attention on its own terms, because it illustrates a specific reasoning pattern that recurs across many wrongful conviction cases, once an initial theory of a case has been publicly committed to. Contradictory physical evidence tends to get absorbed into that theory, rather than treated as grounds for reconsidering it. Here, the absence of any of the 5 defendants' DNA at the scene became, in the prosecution's framing, not evidence against their guilt, but simply proof that a 6th unidentified attacker had also been present, a framing that allowed the original theory of the case, built entirely on the confessions, to survive contact with physical evidence that, viewed independently, pointed in a very different direction. That argument worked. In 1990, following 2 separate trials, all 5 defendants were convicted. Wise, tried as an adult due to his age, received a sentence of 5 to 15 years, and would ultimately serve almost 13 years, including time in adult maximum security facilities, a placement that exposed him to violence the younger defendants, held in juvenile facilities, did not experience in the same way. The other 4 received sentences ranging from 5 to 10 years in juvenile facilities. The trials themselves were held in 2 groups, with the defendants tried separately based on age and the specific charges filed against each. In both trials, the prosecution's case rested overwhelmingly on the videotaped confessions, played for jurors as the centerpiece of the state's evidence, with prosecutors explicitly telling jurors that a videotaped confession from a defendant's own mouth was the strongest form of evidence a courtroom could receive. Defense attorneys in both trials argued that the confessions had been coerced, and specifically that hours of unsupervised, high-pressure questioning had produced statements that did not reflect what any of the defendants had actually witnessed or done. Jurors in both trials ultimately found the confessions more persuasive than the physical evidence that contradicted them. The failures of the system. The failures in this case did not occur at a single point. They accumulated, layer by layer, across nearly every institution meant to prevent exactly this outcome. The interrogations themselves violated what would, in later decades, become widely accepted best practices for questioning juveniles. Practices developed specifically because of cases like this one. Extended questioning without sleep or food is now recognized by forensic psychologists as a primary driver of false confessions, particularly among minors, whose brains are demonstrably less equipped than adult brains to resist the psychological pressure of prolonged, accusatory interrogation. Several of the boys later described being told, falsely, that the others had already confessed and implicated them, a common and, at the time, entirely legal interrogation tactic, despite its well-documented tendency to produce false statements from people desperate simply to end the immediate ordeal in front of them. The physical evidence that contradicted the confessions, the DNA that matched none of the 5, the contradictions between the boys' individual accounts, the absence of any of their fingerprints, hair, or fiber evidence at the actual scene, was known to prosecutors before trial. It was presented to the jury, but framed as a puzzle to be explained away, rather than as exculpatory evidence that should have prompted a fundamental reconsideration of the case. The media environment surrounding the case compounded every institutional failure. Coverage in the days following the boys' arrests frequently used language that presumed guilt well before any trial had occurred, describing the group in terms that dehumanized them collectively, rather than examining the specific and contradictory evidence against each individual defendant. A full-page newspaper advertisement, taken out by businessman Donald Trump roughly 2 weeks after the arrests, called publicly for New York State to reinstate the death penalty, explicitly in response to this case, before any trial had begun, before any evidence had been formally weighed by a court, and while the defendants remained presumed innocent under the law. That advertisement, and the broader media climate it reflected, became, in later years, a frequently cited example of how pre-trial public pressure can shape the environment in which a jury eventually deliberates. The prosecution's own conduct came under scrutiny in later reviews as well. Linda Fairstein, the head of the Manhattan DA's sex crimes unit at the time, oversaw the case and would, for decades afterward, continue publicly defending the convictions even after DNA evidence had exonerated all 5 men, a position she maintained long past the point where the physical evidence supported it, and one that drew significant public criticism, resurfacing intensely following renewed attention to the case in later years. Fairstein's continued public defense of the original convictions, maintained across multiple decades and reaffirmed in various interviews and op-eds, even after Matias Reyes's confession and DNA match, became itself a subject of legal and journalistic scrutiny, distinct from the original case. Her position was that Reyes may have been involved alongside the 5 original defendants, rather than acting alone, an argument that prosecutors' own 2002 review explicitly rejected, based on the absence of any physical evidence connecting any of the 5 men to the scene, combined with the singular, unambiguous nature of the DNA match to Reyes alone. That prosecutors who reopened and reviewed the case in 2002 reached a conclusion directly contradicting the position of the original lead prosecutor is, in itself, a notable feature of how thoroughly the case's foundation had eroded by the time it was formally revisited. Elizabeth Lederer, the assistant district attorney who tried the case in court, also faced renewed public scrutiny decades later, including calls from students and alumni of Columbia Law School, where she had taught as an adjunct lecturer for years following the trial, for her removal from that teaching position, calls that ultimately succeeded in 2019 following the release of the Netflix miniseries and the renewed public attention it generated toward the original prosecution team's conduct. Together, these failures did not represent one bad decision. They represented an entire system: police interrogation practice, prosecutorial discretion, media coverage, and public political pressure, aligning, almost perfectly, around a version of events that turned out to be false, while the physical evidence contradicting that version has sat, largely unexamined in its full implications, in an evidence file for over a decade. The role of the Reed technique specifically deserves closer examination, because it was not a rogue practice used only in this case. It was, and for many years remained, the standard interrogation methodology taught to police departments across the United States. The technique operates on a psychological premise that presenting a suspect with claimed evidence of their guilt, whether real or fabricated, combined with minimizing the perceived consequences of confession and maximizing the discomfort of continued denial, will produce a confession from a guilty suspect. What decades of subsequent research, much of it prompted directly by cases like this one, would go on to establish is that the same technique produces false confessions from innocent suspects at a rate significant enough to demand structural reform, particularly among juveniles, whose still developing brains are measurably less resistant to the specific psychological pressures the technique is built around exploiting. Legal scholars who reviewed this case in the years following the exoneration pointed to several specific interrogation tactics used with the 5 teenagers that have since been identified as especially likely to produce false confessions: extended isolation from any supportive adult presence, explicit or implied threats about what would happen if cooperation was not offered, false claims that other suspects had already confessed and implicated the person being questioned, and, in at least one documented instance, the suggestion that cooperation would allow the teenager to simply go home once a statement was given. An outcome that, for a frightened, exhausted 14-year-old, with no legal understanding of the actual consequences of a taped confession, would have been an enormously powerful incentive to simply say what detectives wanted to hear. The turn in 2001, a man named Matias Reyes, already serving a life sentence in New York State Prison for a string of rapes and 1 murder committed in the years following the Central Park attack, encountered Corey Wise in the general population of a correctional facility. Reyes, by his own later account, felt a stirring of conscience after that encounter. He confessed, unprompted, to a prison counselor that he alone had committed the assault on the Central Park jogger in 1989, a crime that matched his documented pattern of similarly violent attacks against women in the same general area of Manhattan during that period, several of which had already resulted in his conviction. His confession included specific details about the crime scene and the attack that had never been publicly released, details that only someone with direct, first-hand knowledge of the assault could have known. Reyes's own history made the confession, once investigators examined it, difficult to dismiss. He had been convicted separately of a series of rapes committed in the immediate vicinity of Central Park in the months following the jogger attack, along with the murder of a pregnant woman in one of those subsequent assaults. A pattern of extreme, opportunistic sexual violence against women in the same geographic area, during the same general period, that matched the method and brutality of the Central Park jogger attack far more closely than the account given by 5 teenagers with no prior history of anything resembling this kind of crime. Investigators reviewing the case in 2002 noted that Reyes's known pattern of offenses, established independently through his other convictions, was itself a form of corroboration for his confession, well before the DNA results came back. The Manhattan District Attorney's Office reopened the case. DNA evidence recovered from the original crime scene in 1989, evidence that had never matched any of the 5 convicted defendants, was retested against Reyes's genetic profile. It matched. Not partially, not ambiguously. A full confirmed DNA match between Matias Reyes and the biological evidence recovered from the victim, evidence that had sat in storage for over a decade, unmatched to anyone, while 5 other people served years in prison for a crime he alone had committed. In December of 2002, New York Supreme Court Justice Charles Tejada vacated the convictions of all 5 men. The Manhattan District Attorney's Office, under DA Robert Morgenthau, joined the motion to vacate, formally acknowledging that the convictions could not stand in light of the new evidence. The vacatur itself was the product of a formal investigation Morgenthau's office conducted following Reyes's confession, an investigation that included re-interviewing the 5 men, re-examining the original case file in full, and consulting outside legal experts on wrongful conviction cases. The resulting report, made public in 2002, was notably direct in its conclusions. It found no credible evidence connecting any of the 5 men to the assault, beyond the confessions themselves, and it found substantial reason to conclude those confessions did not reflect what had actually occurred. This was, notably, an internal admission from the very office that had originally prosecuted the case 13 years earlier, a rare instance of a prosecutor's office formally reversing its own prior conclusion, rather than simply accepting a court's overturning of the verdict. By the time their names were cleared, the 5 men who had been arrested as teenagers were adults in their late 20s and early 30s. Corey Wise, who had spent the longest time incarcerated of the 5, had spent almost 13 years of his life, including years in maximum security adult facilities, for a crime a DNA test would eventually prove, conclusively, he had never committed. The human cost. The years each of the 5 men spent incarcerated cannot be measured only in months and dates on a legal document. They represent adolescence, early adulthood, relationships, education, and basic freedom, taken from 5 specific people based on a legal process that failed them at nearly every stage. Corey Wise's experience was, by nearly every account, the most severe. Placed in adult facilities because of his age at the time of arrest, he spent years in environments including extended periods in solitary confinement, ostensibly for his own protection, given his age relative to the general adult prison population. He has spoken, in later interviews, about the isolation of those years, in terms that make clear the psychological toll extended far beyond the physical time served. Wise's placement in adult facilities specifically, rather than the juvenile system his 4 co-defendants moved through, has become, in subsequent legal analysis, one of the most frequently cited examples of how a small procedural distinction, being 1 year older at the moment of arrest, can produce a radically different lived experience of incarceration. Where the other 4 men served their sentences in facilities designed around rehabilitation and education for minors, Wise spent significant portions of his sentence in adult maximum security prisons among incarcerated adults convicted of a wide range of violent offenses, an environment legal scholars have since pointed to as substantially more dangerous and substantially less oriented toward any kind of rehabilitation than the juvenile system his co-defendants experienced. Antron McCrae, Kevin Richardson, Yusuf Salam, and Raymond Santana each served their sentences in juvenile facilities and were released as young men who had missed the entirety of a normal adolescence. The years most people spend finishing high school, forming early adult identities, and building the foundational relationships and experiences that shape the rest of a life. They returned to a world that had, in many cases, already decided who they were, based on convictions that would not be formally vacated for years after their release from custody. Each man's path after release from custody, but before formal exoneration in 2002, was shaped by the same basic reality. They were, in the eyes of the law and much of the public, convicted rapists, regardless of what any of them privately knew about their own innocence. Employment, housing, and relationships were all affected by a conviction record that would not be cleared for years, sometimes over a decade, after each man had already served his sentence and returned to ordinary civilian life. Several of the men have described in later interviews the specific difficulty of that intermediate period. No longer incarcerated, but still legally and publicly defined by a crime none of them had committed, with no clear timeline for when or whether that would ever change. The families of the 5 men lived through the same ordeal from the outside. Parents who had, in several documented cases, been present during portions of the interrogations, but were unable to prevent what was happening to their sons, and who then spent over a decade watching their children serve sentences for a crime that DNA evidence would eventually prove they had not committed. The toll on those families extended well beyond the years of incarceration themselves. Siblings grew up with a brother in prison for a crime the family knew, or came to believe, he had not committed, an experience that shaped entire households' relationships with law enforcement, with the media, and with the broader city around them for years. Several parents of the 5 men have spoken publicly about the specific difficulty of watching their sons age through adolescence and early adulthood inside institutional walls, unable to intervene in a legal process that had, in most practical respects, already concluded by the time the family fully understood what was happening. That generational impact, a wrongful conviction's effect, not just on the person convicted, but on the entire family structure surrounding them, is a dimension of this case that receives less public attention than the legal mechanics of the exoneration itself, but one that the men and their relatives have consistently identified in interviews given over the years as among the most lasting consequences of what happened in the spring of 1989. In 2003, the victim of the original assault, Tricia Maley, chose to publicly identify herself, ending 14 years of anonymity, and published a memoir describing her recovery from injuries so severe that doctors had, in the earliest hours after the attack, been uncertain she would survive at all. She has stated publicly, in the years since the men's exoneration, that she has no memory of her attacker or attackers, and that she does not hold the 5 men responsible for what happened to her, a position she reached only after the DNA evidence made clear who was actually responsible. Maley's decision to come forward publicly, more than a decade after the attack, and roughly a year after the 5 men's exoneration, added a dimension to the case that had been largely absent from public discussion for years. The voice of the survivor herself, speaking not to assign blame to the wrongfully convicted men, but to describe her own long, difficult recovery on her own terms, after having had no control over how her case had been used for over a decade. As the basis for convictions, she had no memory of the events behind and no role in securing. In 2014, the city of New York settled a civil lawsuit brought by the 5 men for $41 million, one of the largest settlements of its kind in the city's history, though no amount of financial compensation was ever going to fully account for the years each man had lost. The settlement itself took over a decade to reach following the men's 2002 exoneration, a delay that frustrated the men and their attorneys, who argued the city's reluctance to settle amounted to a continued refusal to fully acknowledge what had happened. The city's eventual settlement, reached under Mayor Bill de Blasio's administration in 2014, followed years of litigation under a previous mayoral administration that had contested the lawsuit far more aggressively, arguing at various points that the original convictions, whatever the DNA evidence ultimately showed, had been obtained in good faith based on the evidence available at the time, an argument the men's attorneys, and eventually the city itself under new leadership, ultimately abandoned. If you've made it this far, you already know this channel is different. Subscribe to Dead Ends and stay with us for every case that was never truly closed. Because even after exoneration, even after a settlement, even after their names were formally cleared by the same court system that once convicted them, the 5 men who came to be known publicly as the Exonerated 5 have spent the rest of their lives explaining over and over in interviews and public appearances they never asked to be responsible for, exactly what happened to them as teenagers, a burden that a wrongful conviction does not simply lift the moment a court vacates it. The case today. As of 2026, the men now collectively known as the Exonerated 5, Antron McCray, Kevin Richardson, Yusuf Salam, Raymond Santana, and Corey Wise, have each built public lives in the decades since their exoneration. Many of them centered directly on criminal justice reform advocacy, informed by their own experience. Yusuf Salam was elected in 2023 to the New York City Council, representing the Harlem district where he grew up, a district not far from Central Park itself. Raymond Santana and Corey Wise have both continued public advocacy work focused on wrongful conviction reform and juvenile interrogation practices, drawing directly on their own case as an example of what those reforms are meant to prevent from happening again. Salam's path from wrongfully convicted teenager to elected city official has, in the years since his 2023 election, become one of the case's most publicly visible legacies. A former defendant, now holding legislative authority over policy in the very city whose police department and prosecutor's office once convicted him of a crime he did not commit. He has spoken publicly, in his capacity as a council member, about using that position specifically to advance criminal justice reform legislation, informed by his own experience, framing his own case less as a personal grievance and more as a documented example of exactly the kind of systemic failure his legislative work is meant to help prevent. Antron McCray has generally maintained a lower public profile than the other 4 men in the years since exoneration, though he has participated in documentary projects and occasional public appearances related to the case, generally emphasizing the toll the ordeal took on his family and his desire, decades later, to be known for more than the 13 years the case defined for him. In 2019, Ava DuVernay's Netflix miniseries, When They See Us, brought the case to a new generation of viewers, dramatizing the interrogations, trials, and years of incarceration in detail that had not previously reached such a wide audience. The series prompted renewed public reckoning with the case, including Linda Fairstein's resignation from several board and publishing positions amid public pressure following the show's release, decades after she had first prosecuted the case. And long after the DNA evidence had already contradicted the position she continued to publicly defend. The renewed attention the series generated extended well beyond a single news cycle. College curricula in criminal justice and law programs across the country began incorporating the case as a central teaching example of wrongful conviction dynamics. Journalism schools used the case to examine the media's role in shaping public perception of unproven allegations. And each of the 5 men, more than 3 decades after their initial arrests, found themselves once again the subject of intense public interest. This time, unlike in 1989, largely sympathetic, though still, by the men's own accounts, in interviews given around the series' release, exhausting in its own way, since it required each of them to revisit publicly, again, an experience they had already spent years trying to process privately. Matias Reyes remains incarcerated in New York State for the crimes he was independently convicted of, including the Central Park assault he ultimately confessed to and was never separately prosecuted for, since the statute of limitations for that specific charge had expired by the time of his 2002 confession, meaning the man whose DNA matched the crime scene. Evidence has never faced a formal charge or sentence specifically for the crime that sent 5 other people to prison in his place. That last fact tends to surprise people encountering this case in detail for the first time. The person whose guilt is not in dispute, whose DNA matched the crime scene evidence conclusively, was never tried or sentenced for the specific crime this entire case was about. A legal outcome that follows directly from how statutes of limitations function, but one that nonetheless leaves the case's resolution feeling, for many who study it closely, incomplete in a way that a formal conviction of Reyes for this specific crime might otherwise have provided. He remains in prison regardless, serving sentences for his other separately prosecuted crimes, which under New York law amount to a life sentence with no realistic possibility of release. New York State and New York City have both, in the years since, implemented reforms to juvenile interrogation practices directly attributable to lessons drawn from this case, including requirements for recorded interrogations in a wider range of circumstances and increased scrutiny of extended, sleep-deprived questioning sessions involving minors. Changes that legal reform advocates consistently point to this case as the primary catalyst for. Beyond New York specifically, this case has been cited repeatedly in national conversations about interrogation reform, contributing to a broader, decades-long shift in how American law enforcement is trained to question juvenile suspects. The Innocence Project and similar wrongful conviction advocacy organizations have referenced this case specifically in advocating for mandatory recording of entire interrogations, not just a final confession segment, precisely because of what happened to these 5 teenagers, a policy position that has since been adopted in varying forms by a number of states and municipalities that did not have such requirements in 1989. The physical and forensic record of the case is, at this point, fully resolved. Unlike many of the cases this channel covers, there is no remaining uncertainty about who committed the crime or about the innocence of the 5 men convicted for it. What remains unresolved, more than 3 decades later, is a broader institutional question this case continues to raise for legal scholars and reform advocates alike. How many other confessions, obtained through similar interrogation methods during the same era and in the decades since, have never been re-examined with the same scrutiny this case eventually received? That question has no clean answer, and it is, in some respects, the most unsettling part of this particular case's legacy. The Central Park 5 case received the scrutiny it eventually did in large part because of a specific, singular event: Matias Reyes' unprompted confession to a prison counselor, more than a decade after the fact, followed by a DNA match that could not be disputed. Most wrongful convictions built on coerced confessions never receive that kind of definitive external correction. They simply remain convictions, on record, indefinitely. Which is precisely why legal researchers who study this case tend to describe it not as an aberration, but as a rare instance where a systemic pattern of failure happened to be corrected, rather than as a pattern that has been meaningfully eliminated from the interrogation practices this case exposed. Closing. 5 confessions. 5 sentences served. 1 piece of DNA evidence that never matched any of them, sitting unresolved for over a decade, while 5 lives moved forward inside prison walls instead of outside them. Whatever this case became in the public imagination, a symbol of racial injustice, a case study in interrogation reform, the subject of a newspaper ad calling for a death penalty that, had it existed at the time, might have ended 5 innocent lives. It began, simply, as 5 teenagers questioned for hours by adults who had already decided, before any evidence was fully examined, exactly what had happened that night in the park. The system that convicted them was not looking for the truth by the time it reached its conclusion. It was looking for an ending the city could accept. It took 13 years and 1 other man's confession for the actual truth to catch up with what the DNA evidence had been quietly saying, unread, the entire time. Consider for a moment what would have happened had Matias Reyes never encountered Corey Wise in that facility. Had that specific chance meeting never occurred, had that particular stirring of conscience never surfaced, there is no guarantee the case would ever have been reopened at all. 5 men might simply have finished serving their sentences decades ago, permanently marked as convicted rapists in the public record, with the actual perpetrator of the crime never facing any specific accountability for it. A scenario that, absent one unplanned conversation in a prison yard, remains the far more common outcome for wrongful convictions built on coerced confessions than the resolution this particular case eventually received. That is perhaps the most sobering thought this case leaves behind. Not the specific details of what happened to 5 teenagers in the spring of 1989, as documented and disturbing as those details remain more than 3 decades later, but the recognition that their exoneration depended on a piece of luck no defendant should ever have to rely on. The system did not correct itself. A stranger's conscience did. This has been Dead Ends. If this case affected you, there are always more that were never truly closed. Subscribe, and we'll bring you the next one.